Good evening, everyone. This is the Monday, March 5th, 2024 meeting of the Zoning Board of Appeals. First thing I'm going to do is we are on Zoom if anybody wants to join us on Zoom. I'm going to take attendance. So, let's see. Alan?
Here.
April Dufo, I'm here. Charles Tremblay, not here yet. Kathleen Burke. Kai Leffler.
Yes, here.
Paul Cadigan.
Here.
And Kevin McDonald.
Here.
All right. The next thing we need to do is elect a secretary, because our secretary has been termed out. The zoning board has a 9-year term limit, so once someone gets to that point,
Oh, sorry.
they get termed out. So our secretary has been termed out, so we need a new one. Do I hear a motion?
Well, I will nominate, I nominate Alan as our secretary.
Do I hear a second?
Second.
All those in favor?
We should ask Alan if it's.
Yeah,
okay
Alan,
with
do you
him.
want to be the secretary?
We did ask him.
Did you? Okay.
Just wanted to,
We wouldn't, this isn't the military, we didn't force him into it. Although I might have twisted his arm just a little bit. All right, the next thing we need to do is approve the minutes from October 3rd, 2022. Wow. I know, and May 8th, 2023. So, let's look at the October one first, because that's the oldest. The October 3rd, 2022, the only people that were at that meeting were Paul and I. So we're the only ones who are going to be able to vote on those minutes.
That's correct.
Paul?
I got a couple of corrections, though, I rarely do.
Okay,
I do.
go for it.
Second page.
Second page.
Which date? Which date?
The October 2nd.
22. I guess this is the fourth to last paragraph that begins with Ms. Gilbert then asked, and that should, this line should say, our grandfather to infinity, as opposed to at infinity.
Okay,
And then in the very last paragraph that begins on this page, Mr. Cadigan asked the applicant if it is his position that to qualify as a lot of, that should be record as opposed to reference.
okay.
On the next page, page
3?
3 on, the third full paragraph that begins with referring to the first page of the application, Mr. Cadigan asked if Attorney Nelson is representing as opposed to
Representing.
presenting. That's it for me on this one. Otherwise, do you have any?
Nope.
I move we accept the minutes as presented, as edited.
Second? All those in favor?
Us.
Okay. And then the May 8th, 2023 minutes, Paul, myself, and Kevin can,
I have one overriding edit to this one.
okay, go for it.
Kevin's last name is McDonald, not Mac.
MC.
MC, not MAC, and that's throughout.
I have no issues, so I make a motion to approve.
Second?
Second.
All those in favor? Okay. We took care of that business. So next thing on, which is not on the agenda, but we're going to do, because we have 4 new members of the zoning board, Amy Chow from Drummond and Woodsum, right, is here to just give us a little talk about our responsibilities as far as being on the zoning board, because we are a quasi-judicial board, and what we decide, the town is bound to. So it's important that we get it right. So we're going to hear Amy give us a little speech.
Okay, would you like me to speak at the podium? Would
Sure.
that be? Okay, be happy to do that. Okay, well, it's nice to see everyone. It's been a little while since I've been before you. Before we get into the matter at hand tonight, I did want to say a little bit, this will be a little bit of a flyby. I do boardsmanship workshops with boards of appeals, and sometimes we can spend an hour or more on issues, and we won't do that here. But I think the most important thing for you to remember as a Board of Appeals is that you are a quasi-judicial board, a quasi-judicial body. What does that mean? And what do I mean by that? Unlike an elected body, you are one of the bodies in town that has permit granting authority or permit review authority, actually, or variance granting authority, which is kind of like a permit, but is sort of listed as an appeal. And because you are in the position of like granting an approval of some kind or approving or denying a prior approval by some other entity or body, like the code enforcement officer, you are conferring a property right. And so what that means is that people who come before you have due process rights. There are procedures that you need to follow. Because you're a quasi-judicial board, you can't be having side conversations with folks on matters that come before you. If you see someone in the grocery store and they want to lobby you for how you should vote on an application that's going to come before you, that's a no-no. That's called an ex parte communication, right? So I would say that's the most important thing. What you need to do as a board is apply the standards in the ordinance that you're required to follow and apply them to the facts of a case. So there are two main buckets that we'll just talk about, and you're here for one of them. Boards of appeals, unlike planning boards, are creatures of statute. There's a statute dealing with the boards of appeals and where their jurisdiction lies. There are actually two statutes, one that deals with variances and the other that deals with kind of what are the various processes and procedures that boards of appeals need to follow. So the two major buckets that I like to talk about are you do variance appeals over here and you do administrative appeals over there. Let's talk about variance appeals really quickly because that's not what you're doing tonight. But that's when someone is seeking a variance and they come to you and it's called a variance appeal, but it's really they're coming to you to see if they can meet the 4 undue hardship standards to basically not follow your ordinance. So, for example, and there are many different kinds of variances, but let's say someone wants to have a setback variance because otherwise they can't build their blank. They need to come to you because the ordinance says, no, you're encroaching into the setback, you can't do that. And there are certain standards by law and under your ordinance that you need to follow to determine whether you can grant the variance. We won't get into all of the, there's no reasonable return and all sorts of other standards. You probably remember that having addressed variance appeals. Have you done that fairly frequently? So that you're probably fairly expert at that. So that's one area. The second discrete area, which is an area that does affect you, is what I call administrative appeals. And those are things that are appeals of other decision makers, local decision makers in town, most often the code enforcement officer. So, and in Kennebunkport, there is an administrative appeal to you for the following. If an aggrieved party is alleging, and I'll paraphrase, that the CEO has made a decision in error that affects them with respect to the review of an action on issuing an application for a permit. That's a mouthful, right? Someone comes to you and says, so for example, tonight, and we won't get into the substance, but we all know that the code enforcement officer in the case that's coming before you issued a permit of some kind. If someone wants to challenge that permit and they file a timely appeal, that appeal would lie before you as the appropriate body. If you grant or deny relief, that can be appealed to Superior Court, but it comes to you first, okay? And so those administrative appeals in Kennebunkport, I will say one thing. Some towns have an appeal right when a code enforcement officer makes an enforcement decision. You know, you need to stop work because you're building something in the shoreland zone. And someone says, well, I want to take an appeal to that. You don't get to hear those appeals. That's the way Kennebunkport's ordinance is written. Just appeals of permit applications is really where things lie in the administrative appeal area. So I was going to cover this anyway with respect to what you're doing tonight. Would it be helpful for me to roll into not the substance of it, but just the procedure that you'll be following tonight? Okay. So one of the important things when you're here reviewing an administrative appeal is deciding what your standard of review is. What does that mean? That's a big legal thing of saying, how should you view the parties who are coming before you? There are two standards of review that could apply, and in your case, it would be de novo. The other standard of review is appellate. Appellate is, if you think about it as like the Supreme Court of Maine would hear an appeal of a lower court's decision. And in doing that, they're looking at a record. They're not having people come up and testify before you and bring evidence in, and you're not making credibility determinations of the evidence that is being brought. So you're not the trial court, you're the appellate court. There are some times when a Board of Appeals does sit in an appellate capacity. In Kennebunkport, for the most part, you are sitting in what's called a de novo capacity. What that means is you are considering matters afresh. So if a party has appealed a decision of the code enforcement officer regarding the granting or denial of a permit, that party can come before you and present evidence to you. They have an appeal that they've presented and written materials. You can ask them questions. So there's both documentary evidence, there's testimony that they can provide. Likewise, then, the code enforcement officer can present evidence to you because the appellant, person appealing, has the burden of proof. The appellant goes first and always has that burden of proof. So if there is a lack of evidence on the record and you find the appellant hasn't met their burden, that's something that you can do. You can also ask the code enforcement officer questions. So it goes around a little bit like a very informal mini trial, all right? And at the end of all of that, you're looking at the facts as they come in and you're applying the standards as they should be applied under your ordinance and coming to a decision. And when you reach that decision, you would need to articulate your reasons for the decision. Because I'm here, I can help you do that if you would like, meaning I can be, Alan will be the best scribe and secretary ever. I could not take his place. But if you would want us to, we can drop a draft decision for you to review. And then you get to discuss it, decide whether it really captured your collective thinking. And then you could put it to a vote. And when you put it to a vote, your ordinance says you have 7 days to issue the written decision, the notice of decision to the parties. In some fairly straightforward cases, you'll be voting on something and issuing that notice of decision on the same date or like very soon thereafter, depending on how things go tonight. When things get a little bit more complicated, I might suggest that you certainly could deliberate and you could kind of give a sense, like a straw poll, perhaps, but without a vote, and then instruct me to go back, write out a draft decision for you. Then you would have to come back a second time, review that decision, take the final vote, and then the notice of decision is signed that same night. I like that. I know it's a little bit more process, but I like that in some cases where it's very important to get the facts down and the reasons for the decision, but we don't have to make you don't have to make a decision on that at the moment. We can see how the evidence comes in. So that's a mouthful. Any questions about that? Anything I missed, Galen?
Amy, how should the board handle third-party or people who are impacted that are not the applicant that's in front of you?
Yes, in the hearing, again, as I said, the applicant goes first, the code enforcement officer can respond, and then obviously this is a public hearing, so you can call upon anyone else in the audience if the public wants to comment, provide commentary. They can provide evidence of how they feel they might be affected by the decision as well, and that you can weigh that evidence in your decision-making. Questions? Okay,
Thank you.
you're welcome. I did want to say something about some threshold issues for every hearing like this. We talked about standard of review, but I like to recommend that you ask if anyone has a conflict of interest that would preclude them from sitting on the board, a perceived or real conflict of interest. In general, you won't have that, but I think it's important to get that on the record. So if you're the best friend of the applicant, or if you're a close relative of the code enforcement officer, these are just examples, right? That's something that you probably should disclose. But, so that's something that's a threshold issue I'd like to have you go through. Also, two more things that are threshold issues, and one is what we call RTI, right, title, and interest. That's just a fancy way of saying, does the person have sufficient right, title, and interest, meaning title to their property and a connection to the permit that would, allow them to come before you. And the related issue here, which is actually more applicable here, is the concept of standing, which is if someone is appealing and feels aggrieved by a decision, they need to show that that there is some particularized injury that their property is suffering as a result of the action taken by the code enforcement officer. Those are threshold issues. They're not usually super controversial, but they are things that probably should be addressed before you get into the merits.
So should I ask the members before we start if they have a conflict of interest?
I do think that's a good idea, yes. And then, yes, go ahead.
I do have one question. So if we opt for what you're recommending, straw poll, and then you all draft a decision, and then we review it later on, so we'd have to meet again. So
Yes.
when we meet again, it would be like a continuation of this meeting, so it doesn't have to be,
Yes.
what's the notice requirement for that follow-up meeting?
I don't think you need separate notice requirements. Assuming that you've met all your notice requirements, this would be a continuation of the hearing. And you would notice that up much like you would any other, I don't know if you do it on the town website or.
Yeah, we put the agenda on the website and posted it in town hall as well.
Yeah. But the newspaper notice and the notice to abutters would not need to be done again.
And then for a time period, I mean, we could do it 7 days from, well, actually, we wouldn't know until we knew what time we're getting the material back from you, your office.
Right.
But do you have a time frame that you anticipate that would be?
I think we could turn it around in a week. So if you wanted to meet as soon as a week later or 2 weeks later, I know in general you don't want to keep folks waiting, so we can accommodate that.
And what's the notice requirement for the town to notice a meeting? Is there a certain period of time?
I believe it's 7 days.
Okay,
Oh, yeah. Is it?
so that would set it a little bit, right?
Right.
Depending on how quickly you were turning it around.
Okay. We good? All right.
I just want to do it. we'll see. We'll see. All right. So we are here tonight for an administrative appeal for John Eagleson and Susan Graham. The applicants are seeking reassurance that no more water will be directed from Lock Street to their property on 12 Oak Street due to permit number 24-17 being issued by the code enforcement officer, David Gilchrist, for clearing and putting a 36-inch culvert as approved by the DEP to gain access to upland for future building projects. And this is map 12, block 1, lot 5A in the village residential zone. So I'm opening the public hearing, and we'll start with the applicant, or the appellant. So Susan, you want to come up and,
Madam Chair, just for clarification, no one has any conflicts of
oh yeah, that's right.
yep. Okay.
How quickly they. Does anybody on the board have a conflict of interest with this application?
I do
I
not.
don't.
I do, I do know the appellant. I have been, many years ago, went to school with the appellant, but I don't, I mean, I feel I can look at this case as de novo.
Okay, I mean, I know the appellant as well. She was a selectman in town, so,
Right.
when I was town clerk,
Right.
so.
It's a small
We all,
town.
yeah, it's a small
Yeah.
town, everybody knows everybody. Okay, Susan, you're up.
Thank you. Good evening, and my name is Susan Graham. I live with John Eagleson, my husband, at 12 Oak Street. I guess I should start out by asking you, before I make a presentation, is there any issue about whether I have a right to be here before you?
We could take that up later, or could take it up now.
If it is an issue, it might save time to do it now. I'd like transparency from the beginning, if there's some question about this.
Well, I'll ask you a question.
Okay, and, okay.
What is your legal relationship to the property?
That I'm the wife of the property owner. Is that not enough?
Are you on the deed?
No.
Oh,
It has Maine revoked dower rights.
Wow, that one I don't know.
Do I need to get my husband here?
Amy?
Do you have authorization from your husband to represent him in this matter?
I certainly do. I speak for him tonight.
I think you can get that on record, that's.
Okay.
Do
I'm
you need that
happy.
in writing? Verbal is adequate for you, for your purposes?
I think so,
Okay.
in these circumstances.
I'm
Maybe
happy to,
would you be willing to follow it up with a letter from your?
of course, of course.
Amy,
I do this all the time with Spectrum, Central Maine Power Company, telephone, if it's not in my name, because Maine hasn't come into the 20th century, 21st century. And
So to just conclude that issue, that you're here on behalf of your husband,
I am,
and that you've verified that you've verbally got authority to do so, and that you can follow
Yes.
that up with some kind of writing for our
happy
record.
to do so.
Great.
I'm happy to do so.
Perfect.
And was there another issue? Is there an issue about whether we have, forget what Amy called it,
Right, title and interest is what Amy said, right?
Well, that's what she just explained.
yes, a
Yeah.
standing issue.
Well, you're
So-
here on behalf of the property owner, and the property owner
Yes.
has submitted, there's record evidence that there's a deed, right, of the property owner,
Yes.
for this, was that submitted with the package?
Well, I'll go ahead and start instead of, is that all right if I just go ahead and
Yeah,
proceed
please do.
with my statement or our statement? I want to start by saying that I have a great deal of respect for this process and the role that you play. This is a community board, but you are representing the town. And my husband and I feel that we're aggrieved parties. You'll find out why. The January 13th storm this year caused a lot of damage to many properties in Kennebunkport and all over Maine. Although our neighborhood is smaller in scale, we experienced a severe flooding event. And I hope that you've read the letters from Steve Centrella and Neil Higgins, who are also property owners in the neighborhood. I'm going to ask that the cover letter that accompanied our appeal of the building permit and another letter to the ZBA that we wrote February 26 and submitted by email, as well as the links to 3 videos, 2 photographs, the town hydrology and contour maps, all be made part of the record. I prefer not to have to read that all into the record. So the Higgins and Centrella property damage was flooding. For us, the impact of the storm was erosion on the southeast corner of our land that abuts the Kennebunk River. And one of the photographs that I submitted with the February 26th letter looks like this. It's the river in the background, and there are 2 piles of rocks. The smaller pile in the front is fill that my husband brought in before I had a chance to take a picture of the hole that was created. The larger rocks behind it are the fill that has previously been buried in about 8 inches of topsoil. I've lived at the property since 1990. John's been there since 61, and we've never seen any erosion like that. We didn't put the rocks there. The town of Kennebunkport did when the exit culvert into the Kennebunk River was installed under Oak Street, under the lawn at our house in the 50s or 60s. We don't even know when it was put in. Why have we filed an appeal of this building permit? This was the first building permit issued by the Code Enforcement Office in Kennebunkport in this neighborhood, as far as I know, since the flooding in January. So we felt we had to speak up about this now. And there seem to be valid concerns about the groundwater flooding. Neither my husband or I object to the construction of an accessory structure or shed on the 11 Lock Street property. We do strongly object to the disturbance and degradation of the wetlands, the removal of vegetation in order to place the structure in a previously undeveloped location. If there are alternative locations for the proposed structure, they should be considered. The DEP permit was issued almost a year ago, and it's too late to appeal that decision. There were no abutter notices, which is standard for the DEP. It's within their discretion. The town does not provide notices to abutters or waiting periods when the building permits are issued. So our first knowledge of the project was when we saw the culvert deposited at the street, at 11 Lock Street, and then an excavator was delivered. To us, it looks as though the DEP and then the Code Enforcement Office failed to consider the context or the local conditions when they issued those permits. The people who live here have shared the history of flooding, would have shared it if the opportunity had been presented ahead of time. I'm not sure that you have to be an engineer to know that removing vegetation, bringing in fill, installing an impervious culvert is going to change the water dynamic within and beyond the wetland. The neighbors are going to have to live with the consequences. Although the culvert is going to allow water to continue to flow within the wetlands, the culvert's not going to absorb any of the water that's now filtered or was filtered and retained in that wetland. The water's not going to dissipate. Removing the vegetation and replacing it with a culvert may increase the velocity of the water. We don't know. I don't know if there are any chemicals applied either to this property or the golf course, which is adjacent to this property, and it's higher than our property. I'm not saying that there are any chemicals, but if they are used, they're now going to flow through a culvert instead of being filtered. And the water that flows through this culvert isn't going to stay on this property. It flows into a culvert under Lock Street that was installed by the town and flows to other properties. And with respect to the claim that the water flow to our property is going to be slowed because the larger 36-inch culvert is moving into smaller culverts, we ask you to consider the photographic evidence from the flood that shows that's not happening. What happens is the floodwaters exceed the capacity of the culvert. They're crossing over town roads and driveways and finding a way to the low point, which is our property. I want you to consider whether a provision in the land use ordinance should be considered for this appeal. Section 24511, and I have taken from it the language that applies to wetlands. I'm not trying to change the meaning, but for some reason, our town has placed the wetlands regulations within the shoreland and resource protection, which makes sense. But we have to remember we have freshwater wetlands as well as coastal wetlands. And this is a freshwater wetland. It's all over the DEP application. So what it says to me is any new permanent temporary structure or use within a wetland shall require a site plan review by the planning board. So that's one question. Why is it not before them? And the other question is, it says no new structure shall be built within a wetland unless the structure requires direct access to the wetland as an operational necessity. Is it an operational necessity for the homeowner to be able to reach this shed by disturbing the wetlands? So we're going to ask you to reverse the building permit with respect to the disturbance of the wetlands. There may be alternative locations for the structure elsewhere on the property as was originally proposed. If no other location is possible, what about a bridge instead of a culvert? If you have any questions, I'll try to answer them, and I'd like to reserve the chance to present any new, to respond to any new information that might be presented.
Questions? Paul?
You've just said that, the relief that you're requesting from this board is precisely what?
To not allow the wetlands disturbance.
And was there an error made? Are you alleging an error that was made by the code officer? You've asked in your materials many questions that you've articulated, particularly in the second packet, where there's like a list of 10 or so questions. And I understand that you were hoping to get answers to those questions, or it seemed like you were posing them to the board. But what is it that you believe, or I haven't seen where you've said that the code officer did something specifically incorrect.
Well, in terms of the permit, I have it in front of, I don't have it in front of me, but I have it in here. And I think I addressed the permit in my February 26th letter. There's nothing in the permit about the amount of fill that's going to be brought in. There's nothing in the permit about where the grading and earth moving is going to happen. Frankly, I will ask you, is it a question of whether, why do we have no reference on our permits to the wetlands? We have resource protection and shoreland, flood zones, and sand dunes. In the language in our land use ordinance, we protect the wetlands, including the freshwater wetlands. But we have nothing in the permit, form. I don't know if there's a protocol that the code officer goes through that's in addition to filling out this. To my knowledge, there was no site visit. Conditions on the ground. It just seems to be a rubber stamp of the DEP permit. And if that's the way things are done, then I, humbly accept that. But I think that property owners have a right to expect the code office would go a little further and look at the local conditions, including the fact that this is in the wetlands. What is the operational necessity for an accessory structure shed on a property that already has space, a lawn, when there's no need to disturb the wetlands?
I understand that you object to this project.
Yes.
This endeavor.
Okay.
I'll try to.
Let me say something, Paul, if I could. The mistake, if one was made, and I humbly apologize for trying to pin this on a town employee, if that's what you're asking me to do. It makes me very uncomfortable. I have the greatest respect for the town employees. But it appears that no consideration was given to the wetlands that are present on the property. Does that answer your question? The mistake would be the error of not looking at the way wetlands are protected in our language of our ordinance, which I read to you from 24511, which either requires planning board review, which would immediately notify all the abutters who could come forward before the permit's issued and voice their objections to more of the wetlands being disturbed in that area. And then second, that the applicant would have to prove operational necessity to do this in the first place. I couldn't even find in the planning board file where the applicant's propane tank is located. And yet that seems to be the basis for granting the right to disturb this wetland. If the code officer has something in the file, how can you give a permit to do something if you don't have the foundation, the reason for giving the permit? Not good enough, huh?
I'm just taking it all in.
You're a tough cookie, and I'm not a lawyer, so,
No, thank you for answering.
May I ask a
Not at
Not
this
yet.
time, no. Oh, sorry. I had one other question.
Go ahead. Do you want to ask another question before I move on?
Yeah, just one thing that I think you were starting to address in your submissions, that there's a 30-day, you need to file the appeal within 30 days of the issuance of the permit.
yes.
And the language is within, and it doesn't say extended for holidays, et cetera.
Yes.
But so you were discussing, but this board does have the opportunity to extend that 30-day period. And is that something that you were trying to convey to us in your submission?
I can address that if you want to hear that. So I noticed the culvert on Friday afternoon of Patriots' Day weekend. I think it was I don't remember the dates. I could look at the dates. Not
President's
Patriots' Day.
Day?
President's Day weekend, sorry. And contacted Lori Smith, the town manager, to find out if the town was going to be installing a culvert in that location, because there's already a culvert under Lock Street over there. And Lori, I got immediately a bounce back that she'd left the office for the day. So the weekend went, and immediately on Tuesday morning, I went to the town office to see the file, and that's the day we filed the appeal. I believe the appeal is timely because I filed it on the first business day after a 3-day holiday weekend. Monday, the 19th, I think, was President's Day, and the town office was closed. But you're right, the ordinance does say you have the discretion, but I didn't want to take any chances. So I think we met the deadline.
Okay, thanks from me.
Alan, did you want to ask a question?
Yes. Susan, Paul asked you what relief you were seeking,
Yes.
and I think you said to reverse the decision. Is that correct?
To reverse the portion of the decision to disturb the wetlands. We don't have any objection to the shed accessory structure being located on the property, just not in the wetlands.
Okay, so understanding that, what is the corrective action that you're seeking?
Well, and again, I'm not a lawyer, but the ordinance seems to indicate if you're going to go into the wetlands, the planning board should be looking at it, not the code officer.
So
So
this
the
is for,
relief,
this
you-
is for future
you have.
activity.
Ask Amy, you would check with Amy. I believe you have the authority to forward this to the planning board as one of your remedies. You can, deny me, you can approve my appeal, you can send it to the planning board. So that would be the remedy. Let them have the hearing and determine if the wetlands issue is a valid one for their review.
Thank you.
Any other questions?
No,
Kevin?
she answered my
Thank you
questions.
very much.
Yeah, thank
Okay,
you.
we may call you back if we have some more
right here.
questions. Okay, next would be Code Enforcement Officer. So, Galen, are you going to speak?
No, Greg Reed is here representing the code enforcement officer,
Okay.
so I'll ask him to go up to the podium.
Yeah, Greg Reed, Assistant Code Enforcement Officer. So, your questions?
Do you want to explain?
Well, I mean, typically what we do, we have a plan which was done by Longview Associates and approved by the Department of Environmental Protection. In this case, we don't review individual lots generally when it comes to water and runoffs and things, because we rely on DEP with their knowledge. We don't have the knowledge usually in-house to take care of, these situations. So we rely on their expertise in this case to do a permit. Now, when David issued this permit, he took Jim's plan from Longview Associates, and he took the DEP findings and issued that just the permit to put the culvert in. We have not issued any building permits on the property. We just issued, and it states clearing and putting a 36-inch culvert as approved by DEP to gain access for the upland for a future building project. And that's what our office approved. So based again on the DEP approval and the plan that was submitted to us by Longview Associates.
Okay. So you issued the building permit based on the fact that the DEP issued their permit.
Yes, we issued that, but. No, it's used, no, it's not, it's a land use permit. Yeah, that's what I said. We have not issued a building permit. We issued a permit to allow the culvert to be installed.
Based on the fact that the DEP
The-
issued their
based on
permit
their
first.
approval, that's correct. Yes, we never could make those decisions without DEP's approval first.
And, okay. So your decision was based on DEP's decision.
Yeah, and the plan that Longview Associates, that the rest of the property, you know, that it worked from our end of the spectrum. That the property, the upland was, you know, there and the upland area was there, so that was not an issue.
Okay. Other questions? Paul?
Yeah, I have a question. Just, on the application for permit, I guess it is. So under number 3, it says, is the proposed work in any of the following zones? And so is the work being done in the resource protection zone or the shoreland zone? They're both checked as no.
Right.
And I just wanted to confirm that.
It's not a resource protection zone and is out of the shoreline zone. Right.
Okay, I didn't know if,
And the flood zone and the sand dunes, all four are correct.
okay, and wetlands by
Well, this is
themselves.
a freshwater wetland, so by itself it's differently than a shoreland zone or a coastal wetland would
Okay,
be.
okay, because it's a freshwater. Okay. So that is the reason those are checked now. Okay, thank you.
Paul?
So, the applicant raised the question of why this application wouldn't come under section 5.11, the structures and uses extending over or below normal high water line or within wetland. Can you tell the board why this would not have been, that this application would not have been directed to the planning board? Do you know which what I'm referencing?
Yeah, I think, is that in the shoreline zone reference?
That's a shoreline zone reference to the
Yeah.
site plan review. for the
Right,
plan.
that's a shoreline zone reference, not an individual lot reference. I mean, it's typically, if somebody comes in with a property and they have a small area of wetland that they maybe want to do a crossing or something like this, you know, these typically never go to planning board because it's an inland wetland, you know, and it's approved by the DEP to do a crossing generally. We make sure they have enough upland, you know, and satisfy our requirements for setbacks and uplands and so forth. And, but typically, we don't review these as part, like a shoreland application.
So the reason it didn't go to the planning board is because this doesn't qualify under that section, because it isn't in the shoreland or the resource
Correct.
protection, right?
You would have to refer back to the land use code definition for what a freshwater wetland is.
Yes, one of our 4 favorite wetlands.
Yes.
Yeah,
Can I ask another question?
sure.
This culvert that's getting put onto this property, is the beginning and end of the culvert on the property?
Yes.
So the water is being taken from the higher area, or,
It's basically a leveling of the water, so to speak, in a way. If you take a wetland area here, and it's continuous for now, let's say to the end of this building, and I put this culvert here, all it's doing is balancing this wetland side with this wetland side. It's not changing the water level of it's made to maintain the balance of that wetland area, if I'm saying that correctly.
and the culvert isn't flowing out onto somebody else's property?
It is not. No, it's within the property.
And prior to the culvert going in, it was a contiguous piece of wetland, right?
Yes, and the culvert, in a sense, Paul, it still is, because the water flows.
Right,
And that, and continue, makes that stay that way.
Right. I'll just note one thing that really isn't to do with them, but when you made reference to the building permit and it was said that this is a land use, it's on a form that says building permit on it.
That's, yes,
So I
But
take a
there's-
reference to it as a building permit.
but the application
Understandable.
is a land use permit.
Right, right.
Yeah.
I think it's further confusing because structure doesn't apply to culverts, I don't believe. If we can call it a culvert a structure, I got problems with setbacks.
Yeah, we know, culverts aren't structured.
Yeah.
No.
You good? Kevin?
I just want to verify the resource protection zone and the, what's the other?
Shoreline?
Shoreline, don't apply to freshwater wetlands?
In this case, they do not apply it to this wetland, yes.
Okay. Where is that defined? I guess it would be good if we review that, prior to,
I'll pass down my definition for you if you want that.
that would be great.
Yep.
Do you want me to read it?
Just
into
give
the
it back.
record? I can read it into the record if you like.
Yeah.
Yeah,
So a freshwater wetland, there's a lot of different categories. Is freshwater swamps, marshes, bogs, and similar areas other than forested wetlands, which are, and then there are wetlands, freshwater wetlands that are of 10 or more contiguous acres. Does
Which
this
is-
meet that?
No,
Okay, so let's skip that.
Yep.
Then there are freshwater wetlands that may contain small stream channels or inclusions of land that do not conform to the criteria of this definition. Does this fit that
no
definition?
stream.
Okay, so I think we're in C, which talks about freshwater or forested wetlands of less than 10 contiguous acres, but greater than 2 contiguous acres. Are
And
we
this
in
is
that?
not- This is not a forested wetland because of the growth,
It's a freshwater wetland, is it less than 2 contiguous acres?
yes.
Okay,
Yeah, it's
so-
a very
so-
Small area, I don't know if it
So
says
it-
on that.
Well, hold that thought, and I'll just read it into the record, and you can decide whether it fits
Okay, yep,
in or out. So if we have a freshwater wetland that is less than 2 acres, it is not subject to inclusion in the Resource Protection District and shall not require any shoreline zoning structure setbacks.
because the resource protection calls out freshwater wetlands,
That meet that definition.
but this overrides that by saying less than 2 acres. Okay, perfect. Thanks.
And
So that might be, I'm sorry, that might be a fact you will want to have clarified factually in the record.
Yeah.
this permit is just for the culvert. It is not for the shed.
that is correct.
So there's no.
We have a pending permit and on file right now for the shed, but it has not been issued.
It's not finished, okay. Anybody have any other questions of code enforcement?
Not me.
All right, is there anybody from the public who would like to speak? That would be your cue.
Thank you, board members. I appreciate the opportunity to appear before you tonight. My name is Jim Logan. I'm a wetland scientist, soil scientist, licensed by the state of Maine, and also a septic system designer. I formerly worked for 25 years or so for Albert Frick Associates out of Gorham, and then started our own firm. We have an office in Kennebunk. I've been there this is the 8th year now. I can tell you, based on the thickness of these two files, that we've done full diligence, not just with the DEP. This culvert pipe was also permitted by the U.S. Army Corps of Engineers, which is the reason why it's a 3-foot diameter culvert, because that's what the Corps stresses and specifies for this type of crossing. Ironic that the Corps is involved because there is no navigable waterway of the United States there, which is their authorization. However, we did obtain the permit through the Corps as well, because it is part of the process that we are bound by. For the board's edification, about 8 to 10 inches of that culvert is bedded into the bottom of that wetland. So there's already not 3 feet of cross-section available for water to travel through. That's referencing Greg's comment about providing equal hydrology on either side of the pipe, both the upstream side and the downstream side. A letter that I submitted to the board suggests that there's a 2-foot culvert, a 24-inch culvert, draining under Lock Street. And just in front of that culvert is a little depression that I believe the town of Kennebunkport dug out so that water would sit there for a period of time during a storm event before it pulsed through that 24-inch culvert. That 24-inch culvert under Lock Street goes to a 20-inch culvert that's under the private driveway. I think it goes to Gordon Ayers' lot, if I'm not mistaken. I may have that wrong. And then it heads down towards Oak Street. I drove Oak Street today looking, and I don't see a good functioning culvert under Oak Street at all. And whoever has the house at 15 Oak Street, a neighbor, direct neighbor, has put a beautiful circular gravel driveway in, right above where all this drainage water wants to collect and go under Oak Street to get to the marsh. So again, my letter indicates to you, as well as anybody in the public, that there is local effects much closer to the appellant in this case that is having far more effect on the drainage difficulties that they're experiencing than my individual at the top of the hill with the 36-inch pipe. Stormwater laws in the state of Maine say for a private landowner, if you're not ending up with at least 20,000 or a half of an acre, 20,000 square feet, or half of an acre of impervious surface, you are not subject to the Maine stormwater law at all. And that would even be up to an acre before you needed a permit. You do a permit by rule between a half of an acre and an acre. We have nothing like that. Mr. Tomasulo's permit enabled a 40-foot long culvert to go into that wetland in order to cross. We needed nothing like that. Mr. Tomasulo purchased a 20-foot culvert. So of the amount of permitted fill, we've got about a little over half of that going into this wetland. We've reduced the amount of fill that was allowed by our permit, okay? And then it just appears to me that the part of Oak Street that's experiencing the difficulty, I don't think there's adequate culverting under Oak Street at that location, which I think is really the point of pinch, causing the backflow into these neighbors' areas. And I would even suggest that the big parking lot at the 1802 house that's next door to Mr. Tomasulo, business use, is far larger and impervious than anything Mr. Tomasulo is doing on the neighbor's lot, or his lot. So I understand how the recent placed pipe on the side of the Lock Street caused a lot of people to get up in arms and point fingers. I would suggest to you that the finger pointing needs to be much wider around the neighborhood and not specifically Mr. Tomasulo. And if you have other questions, I'm available to answer, provided they're technical and not legal.
Tell me again about what you said about runoff from a person's property?
The stormwater law in the state of Maine, this is the one that guides sort of the overreaching land use law in the state of Maine that is administered by the state, says that you need to disturb more than you need to have at least a half of an acre of impervious surface you're creating in order to be subject to the Maine stormwater law.
Oh,
And then over an acre, you actually need a real permit, a stormwater permit from the state. That would undergo stormwater review. That's chapter 500 of the Maine Department of Environmental Protection laws. And they're in the process of revising those laws again, particularly for large commercial activities, because runoff is an issue. The state hasn't determined that the effects at the individual homeowner level are large enough yet to chase after. And they are talking about changes to the stormwater laws. I was at a seminar just last week where this came up in discussion, but I know of no attempt by DEP to get down to a single individual landowner like sort of a single-family dwelling situation, unless you should have that half of an acre or 1 acre. Think about it, you need a 100 by 200-foot building, commercial building, to have a half of an acre impervious. So it takes a pretty good size area before you trigger the law.
Okay, and so the state, that's a state law, and the state has,
Again, what we did was we obtained permits for a wetland impact. That's the placement of the pipe in the culvert. Again, placement of the culvert into the wetland. We've reduced the footprint of that fill material on purpose. And that culvert, again, is designed to allow water to just flow through, pass through from the uphill side to the downhill side. The reason the bed the culvert 6 inches in is to maintain the hydrology from the uphill side to the downhill side. And that's for any species that might live there, so that they can travel through the pipe unfettered. Okay?
Point of privilege, Madam Chair. If, just a kind reminder to the board members to please lean into the microphones. We do have staff that are looking at transcribing tonight's meeting, and we need to make sure they can hear you.
April, I have a question.
go ahead, Kai.
Just thinking about, on a common sense level, if you've got a 36-inch culvert, that the water that's in there is going to be, I've got neighbors that have frozen yards, and the rain came, and the 13th was a nightmare for everybody. But if you have frozen ground, it can't go anywhere. If you've got a 36-inch culvert that is leveling everything, I would think it would keep water off of the neighbors and would keep the water all in that space, if you will.
I referenced that in my letter, where I think the 24-inch pipe under Lock Street acts as a barrier, in essence causing, what we do with stormwater design is we contain
Right.
stormwater runoff on the site and then it's released as a pulse, as the pipe can handle it, or as the structure can handle it, whatever, I shouldn't use the term structure, as the pipe that's under the road can handle it.
Right.
So I know the appellant wanted to cast dispersion on the notion that 36-inch, the fact that it's 36-inch has no bearing on the downhill runoff volume. It's allowing the flow through naturally. It's the 24-inch pipe, and furthermore, the 20-inch pipe that's under the private driveway. This is in the same drainage way. Once they start to back up because they're filling, well, that's part of the pulse. That's the retaining of the stormwater on our site until such time as the pipe can handle it. So, in effect, that basin, that little cuffed out, that scooped out area at the head of the culvert under Lock Street, which is below the bottom of the pipe, acts as storage for stormwater until the pipe can receive it and accept it and send it downstream.
Right, right.
Now, again, if you're looking at an air photo with the drainages, the town map does a good job of showing where the little drainages go. There's actually a culvert under Lock Street that feeds into the wetland behind Mr. Tomasulo's house. That's only a 1-foot culvert. So we got a 1 going to a 3 and then following a 24-inch under the town road down to a 20-inch. And yet they're still having problems down on Oak Street. So again, I'm going to suggest it's probably not this individual. It's collectively the neighborhood. There's an accessory dwelling on the abutting lot to these people that's new. The neighbor up on the corner, map 9, block 2, lot 1, I don't know who that is, on the corner of Lock Street and Oak Street on the inside corner, big house. My understanding is they just put porches on with new roof lines. And all those roofs are directed right at the location where these photographs were taken. So I would suggest to this board that more of the immediate problem they're experiencing, in addition to the fact that we had 2 of the wettest seasons, 2 of the wettest years on record, recorded. And this is not the only place, maybe it is that Oak Street and the town needs to look at enhancing the drainage under Oak Street to get the water out of the loop that is Oak and Lock and get it safely to the marsh.
Right.
Over in Kennebunk, I work over there a lot. I'm working with the town over there because they've got an old town road, not well constructed, been there forever, that doesn't have adequate drainage going out from under it. And I'm working with the town of Kennebunk so they can upsize that culvert.
Thank you.
Yes, how much of the permitted work is complete and how much remains to be done?
Very little needs to be done to complete. The pipe is set. It's only 20 feet, not 40. So I'd like to point that out to the appellant. And the fill associated with that, while it's not exactly half of what we asked in the permit because it fans out back into the uplands away from the culvert head, it's probably 60% of the permitted amount. And if it pleases the board, we were in the process with the surveyor of mapping that. We didn't get that onto paper for tonight's meeting, but I can show that to you if Amy feels like that's material to this case. So, really all that's left to do with that, the fill has been placed in the wetland. The culvert is armored in the fashion it's supposed to be. They've stopped filling over the top of the pipe. But they've already matched uplands on either side. So in order to do what this woman would like to do, now we're gonna have to restore a wetland that has fill in it already. And I don't recommend that as a good choice particularly. There's not a lot of impact with this pipe.
Amy, do you have a question?
I just had one clarifying question. So I'm looking at this map showing 875 square feet. Are you saying that the fill area is 60% of the 875?
That would be,
I just wanted to understand.
that's my best guess.
Yeah.
Here today. Again, we had the surveyor out there the other day. We had a meeting out on the site with the guy that had the machine, the excavator, sent him away because we had a stop work order, and we would be mapping accurately the toe of that fill, and the surveyor could produce that accurate square footage calculation.
But as mapped here, it's a fair bit less than what is shown on this plan.
Correct. What's on site on Lock Street is a good degree less than what was permitted, yes.
Any other questions? No. Mr. Tomasulo, would you like to say something?
I just appreciate your time today. And I understand, the flooding that's gone on Lock Street. I've been here myself 7 years, and it has not looked like it has over the last 2 or 3. Just we're getting historical rainfalls. I've tried to be very, very prudent with just not only this project, but my previous property. I've had Jim, you see the folder there. I've been very cautious and very diligent on making sure everything was met by code, DEP, Army Corps of Engineers. Even in this project, we shrank on our own without needing to. I could have done a lot more work had I done a 40-foot culvert and used all that fill. We shrunk it down just enough to be able to get through to the other side and do the work we needed. Again, trying to be very cautious of wetland impact. I don't think in any way, shape, or form this 500 square feet of fill is going to impact the neighborhood. I think it's easy to point the finger at the new guy when people are seeing flooding, but I don't think that's the case at all. And I think Jim has shown a lot of evidence to that fact. And again, I'm not an attorney. I spent all weekend trying to review the codes and ordinances. I still haven't found anything that shows that I've breached any kind of code or ordinance here. And I know that's the purpose of this hearing is to undo a wrong. Unless I'm mistaken, I haven't heard what that wrong is yet, and I'm trying to understand why we're here. If no code and no ordinance has been broken in any way, shape, or form, what the appeal is for. So, thank you.
You're welcome. Anybody else from the public would like to speak? Susan, would you like to speak again?
So, hearing that this is all our fault. In your file, I think you have a copy of the Longview Associates map of the property. This was the map that was used for the house permit. When it was originally submitted to the DEP, there was a proposal to put the accessory structure next to the proposed dwelling. uh, if you have this, do you have this map? Would you note that there's a yellow line, which is the limits of the proposed wetland alteration for the house? And then there's a green line, squiggly. And between those two lines, it clearly states forested and scrub shrub freshwater wetlands. Okay. From there, I bring you back to the zoning ordinance 24511, which provides protection to our wetlands. Kennebunkport has the right to have a stricter ordinance than the state requires. And the DEP doesn't look at our local ordinance. They look at the state ordinance. It's my opinion as a layperson who cares about Kennebunkport that whoever wrote this ordinance, and we all voted on it, we all approved it. I didn't make it up. It protects our wetlands, not just the shoreline, not just the resource protection area. I contacted the DEP regional office to get a copy of their file, their application for this permit. Is that in the file? Do you have a copy of that?
The DEP application?
Yes.
Yes.
Okay. Does anyone on the board know where the propane tank is located on the property? Can you have you heard from anyone tonight where the propane tank is located? I'm not hearing any yeses, and yet the propane tank was used as the reason to get the new permit from the DEP to do all this additional work on undisturbed wetlands. The DEP has a copy of that. It should be in your file, but I shouldn't have to make the case for the person that has the permit. I disagree with the conclusion that water always stays in the culverts. You should have a copy of a photograph in your file that was submitted by me, I think, showing water flowing over the driveway for 16 Lock Street. The fact of the matter is the water flows from 11 Lock Street into a town culvert under Lock Street across the road. And if there's too much water, it flows over that driveway. In my videos, I provided you with evidence that the water is flowing over Oak Street because there was too much water. This is not a random event. I did not make photocopies of this, but I'm going to show you all photographs from 1999 when we had the very same type of flooding event. They're dated on the back, the photographs, and they're identified. This all happened before there was any construction in the center of this block, the current air properties. They weren't even there. So I'm going to hand these around for you to look at. I'm trying to make the point that it's not something that happened just the last 2 years. This has been going on for years. And every time the wetlands get disturbed, it gets worse. The town permit, I think I heard Greg say that the permit was only for the culvert. Have you looked at the permit? The permit is for filling, grading, and earth moving. Now, that may be in relation to the culvert, but it's for more than the culvert. I don't think Jim saw the videos of the flooding. So I'll pass out the photographs of this previous event, which was 25 years ago.
Is there any response that I can make to that?
Sure, if you want to.
Very briefly.
respond
Two
briefly.
2 points to bring. We don't get a DEP permit without an alternatives analysis. This woman keeps talking about other places on the lot. We did, again, you don't obtain a DEP permit without an alternatives analysis. And the mantra for DEP is first avoidance, and if you can avoid it, you don't do it. There's no way to get to that other piece of property from Mr. Tomasulo besides a small piece of fill and a culvert. She did mention a bridge, but there's no access from any part of Lock Street that can get him access to that piece of upland, and the side driveway alongside of his abutting sideline is a private right-of-way that belongs to someone else. So he has no access to that piece of upland any other way but through the rest of his property. So,
April,
go
I
ahead.
do have a question for you.
Yep.
So what requires you to go to the DEP in the first place for this work?
The
What-
fact that the total fill on this lot was in excess of 4,300 square feet. This board needs to understand, maybe this lady here needs to understand that
Yeah.
I'm sorry.
I have a name, Susan.
Susan, okay, that, as read to Amy, certain wetlands in the town which are not in the shoreline zone and are not resource protected and are not in excess of 2 acres or 10 acres are eligible for a DEP exemption. DEP actually allows, in certain instances, an exemption where you don't even need to report your activity. And Greg faces this all the time because people come in and say, well, I got a little wetland fill, I need to put in 300 feet of fill for a culvert for my driveway, for a single-family home. And it's not a RP, and it's not a shoreline zone. He looks on his map, and it's an isolated small wetland pocket. And we might even go further because we know the vernal pools are important. So as a wetland scientist, I'm going to prove for my client that it's not a vernal pool because that would be overseen by the DEP in a different way. So there are occasions in this town where if it's 300 or 400 or 500 square feet and it's in a certain kind of wetland, here's where I would like to say, not all wetlands are exactly the same. That's why this ordinance has 3 or 4 different sections. And the DEP therefore treats them differently.
Okay, so just so I'm clear on it, the requirement to go to the DEP was for the original permit when the home was built. Is that right?
Correct.
And it was because of the size of
The size of
that requirement?
most times, and this was a lot of record, he didn't have a choice. It came to him available on the market as it was. There was no ability to add more land in any direction.
Okay, and you had to go to the DEP again because it was
It was additional on top.
additional work on top of the original
The
permit?
legal term people like to say it was a cumulative impact.
Okay, so that's the reason you went to the DEP. And what was the reason you went to the U.S. Army Corps?
Because many fills in the state of Maine in a wetland also require Corps review and approval.
Okay, so
And in this case-
that's a state requirement tied to the DEP?
No,
somewhat?
the Army Corps is federal. You understand, we got the
Oh, right,
DEP at the state
right,
level, the
federal.
Army Corps of Engineers at federal level. Some of it is overlapping, some is not. Occasionally, you need a DEP permit and not a Corps permit. Other times, you need both, and sometimes you need a Corps permit, but not a DEP permit.
Okay.
That's the Fair Wetland Scientist Act, that keeps us all real busy, because it's complicated. In his case, he needed both.
Okay, thank you.
Nina?
I'm Nina Perlmutter. I'm in a butter to Mr. Tomasulo. And of course, I've known Susan for years. And I'm on the planning board, so most of you know me, or at least by sight, or people have talked about some of the things I've said, one or the other. But I have to make a couple of points here, because I don't completely agree with Jim. Again, I have no problem with Mr. Tomasulo building his building on his property. I worry about that little piece of wetlands, however, and I think Jim may have made an error in a couple of places. I don't know, I'm not a soil scientist, I am an aquatic biologist, and I know I look at streams quite a bit. And of course, that property, I owned that property at one time. I sold out to people.
That is the irony here,
Yes, I know. And I sold it off. You know, and it was all divided after my mother-in-law died. We won't go into that. I don't think what is being done will affect me. I want to make that point. I understand, however, Susan's concerns. When I looked at the DEP permit that was filed, and it was mentioned or stated in there that the little water course in there was not a water course or a stream. I would dispute that. Okay, I know you're a soil scientist, and I know you know your business, and you've worked for me, and you've done a great job. However, I've gone and looked at the state requirements for defining something as a stream or water course, and I don't know, but I've watched that little piece of wetlands for many, many years. I've been up there with my mother-in-law, and we built a house. Of course, we've been there 20 years. It's been 30, 35 years. It's never been dry. Never, even in drought years. And I think some of the water going into it flows from some drainage that the golf course put in probably before zoning, because I know they have drains near that property for water coming off the golf course that is going down towards that. I think it really is a water course, not a man-made thing. And I think, given that, the DEP might have looked at it differently. I don't know. I don't know what the requirements are, okay? Stop right there. Don't say another thing.
How can you say I'm wrong and then say you don't know?
Okay. I said you may have made an error, okay? Stop there. Anyway, I have a rain gauge on my property, a weather station, and I've been watching the rain over the last couple of years. We normally get in our area about 40, 42 inches of rain a year. Last year, we got over 60. It was closer to 65. I've been reading about climate change. Being a scientist, I'm always reading about what's going to happen in New England. And it's very clear that certain times of year, we're going to get heavier and more violent storms, which means more flooding during the winter and the spring. There's no question about it. It doesn't bother me that he put in a bigger culvert there. It really doesn't. I don't know culvert science, and I'll take Jim's word for how it's going to flow. But I do know that when you clear a wetland area and the vegetation that takes up that water, it's a problem. Now, when the contractor came out and his guy started clearing things, I went out there and, beside the fact that I chastised him for driving over my property without permission, I asked him if he was going to take out the large pine there, and he said they were planning to. There's an elm there that's growing, that's on the corner of the wetlands, and there's a big pine in there. Most of the vegetation, the trees, have been killed by bittersweet. Nobody's been going in there except when I owned the property. I went in there and cleared some, and I tried to keep it clear off the pine because I know that a pine that size can take out thousands and thousands of gallons of water. Something like, it's estimated 11,000 gallons a year. So I don't worry about the culvert. I worry about having clearing an impervious area in a place that was previously a wetland, that there may be enough runoff there to really increase the water going through either one of those culverts. And that bothers me a bit. It's something for you to chew on. I'm not going to make a decision on it. I don't know enough about it. But I think it's something that needs to be considered when you go into a wetland. as an abutter, of course, I was never given notice of this. And like Susan, the first time I knew anything of it was, there was a surveyor out there, and I talked to him, and he was fine. He had trouble finding the pins, and I showed him where they are, since I was there when they put them in. But I've lost my train of thought. Anyway, I think that, in Kennebunkport, where people tend to start worrying about going into the wetlands, because on the planning board, I see this all the time. We're going into more and more marginal lands. The contractors want to be in there. And the neighbors are getting up in arms about, am I going to have my lawn flooded? What's going to happen to the water when you put in a house and a driveway and so forth? And, there's very little land left that doesn't have a wetland on it. I think we need to look to the future in Kennebunkport and maybe inform abutters when something like this is going to happen, so we can all work out a plan. You can sit down with Mr. Tomasulo and Jim and so forth, and Susan and so forth, and the neighbors get together and they find a solution. We often have that happen on the planning board because abutters get notice and they come in and they say, what about headlights this way? What about runoff on my property? And that's when the contractors start talking to them and they work out a solution. So that's my 2 cents. I think, just having the code enforcement officer rubber stamp DEP permit is not the way to go anymore. I think it needs a little more information and a little more input. Now you can
Thank you.
talk.
No, we can't.
Oh, okay.
Can I?
Yeah, go ahead.
So, thanks for all your comments. But I just want to follow up a couple on that you didn't get notice, just like the appellant didn't get specific notice, but you don't say there was anything.
I didn't get any notice at all.
Right, but you don't know that to be against the ordinance, that there was.
No, I don't think it is against
Okay.
the ordinance.
Okay.
I understand that, what goes into the code enforcement office, in the DEP permits, there's no notice there.
Okay.
What I'm saying is, maybe there should be
Maybe,
notice.
but that's nothing that we
That's
could do here.
No,
in
that's
our-
nothing you can do there. We
Yeah.
have to talk to Galen about that and bring it back to Lori and,
And
and the Board
whole,
of Selectmen.
And then when you were talking about that bittersweet has been killing the trees off.
Oh, yeah.
The tree, there was nothing in the, there was nothing in the town's permit that provided for tree removal.
No,
Okay, so you're not, with regard to your comments on the trees, you're not talking about the permit that was issued by the code officer?
no.
Okay.
There was no permit to take down the tree.
And then with regard, I'm just trying to make sure, this is a hearing with regard to the permit that was issued, so I'm trying to make sure if comments are directed towards that or towards the greater picture, the greater good. And when you were saying that, differing with Jim with regard to the definition of what or what not is a stream.
Well, that would be the DEP
That would be
permit,
the-
and that's already a done deal.
And but that is the DEP as opposed to the town's
That's
issued
right,
permit.
that's right.
That's all I wanted to
But
clarify.
what I'm saying is that in the future, you really need to have the code enforcement officer come out and look at the wetlands and look at the trees out there, just like they do in the shoreland zone and the resource protection zone. So,
Thanks.
okay?
And I do believe all building permits are posted on the town's website, aren't they?
Yep.
Yes, so anybody can go on the town's website and look up building permits, but they are not, you are not required to notice abutters when just a basic building permit is
You
issued,
know,
so.
But this was not a building permit.
right. There's
True.
land use permit.
Land use permit.
I don't want to belabor too much of the board's time, but there is a clear 5-part litmus test in the DEP statutes and standards that say what a stream is. And you need 2 of those 5 criteria present, and we don't have it. So it's pretty explicit. I don't know if
No,
Nina's-
we don't.
you don't need to
We
hear
don't
it,
wanna
but
go
I'm
through it,
saying,
yeah.
there's a 5-part litmus test.
No,
It's pretty-
I don't
And I
wanna
know it
hear
pretty
it.
well, and we don't have it met, so.
Jim, I have one simple question for you.
A simple one?
A simple one.
I
It's very
rarely
easy.
get simple ones.
What size is the wetland that's on the premise of 11 Lock Street?
The portion, well, I'm not authorized to go off-site, so you've got to be, you're just talking about the part on our lot.
Well, it's the entire wetland.
Well, there's my issue, because I don't have right of access onto abutting properties. So in order to be accurate and map, here's part of the problem with the way the ordinance is written, different subject, different attempt here, Amy. A lot of the old jargon and wording in the ordinances are based on outdated wetland regulations, i.e. the reference to a 10-acre threshold wetland. DEP has no such reference to that anymore. That's how it got in there in the beginning. So I would suggest to you that some of the references in the town ordinance are based on old nomenclature from the DEP that is no longer in use. The 10-acre threshold went away in the 1995 revision of the DEP Natural Resource Protection Act standards. That's when they made the 1/10 of 1 acre exemption allowance. So that's a point of
So Galen, you didn't get your question
However,
answered.
it's a narrow wetland. Galen, and my best response to you would be the way I address it with all the code people. In Kennebunk, the whole ordinance is based on the acreage of the wetland. So I'm faced with this all the time, and we make an effort to go through a process where we use the best topographic information we can. We put an air photo behind it so we can see where the scrub wetlands are versus forested, and then we make our best guess as to the size of the wetland on the abutting property.
Have you done that here?
We have not. We have not. I could easily do that as part of this deliberation. Haven't got to that. Didn't think that was important because we felt like it was clearly under 2
Do you have an estimate?
Well, in this case, what's important here, and if you were to codify this in the town ordinance, you would want to utilize roadways as breaks, because culverts under roads don't constitute wetlands or wetland connections. DEP commonly holds roadways as the jurisdictional break in an area calculation. So in the event that's the methodology we were using, these wetlands are so narrow, they're fingered wetlands, they're a little narrow bottom of the swale type of thing. I couldn't make 2 acres out of this wetland till I got back to Lock Street, around behind Mr. Tomasulo's house, or all the way up along the edge of the golf course back to North Street, which is where another culvert comes under the road. So I don't think I'd have 2 acres.
Okay. Anybody else want to speak?
Could I move this back so I can see everybody?
Sure. Is that okay for you, Dave? Okay.
I just wanted to put one point of clarification. If you
Okay.
look at our shoreland zoning map, this wetland is not mapped on our shoreland zoning or resource protection zone. So,
Okay, so was it because it was too small to be included?
that's our assumption, yes.
Okay. Anybody else on the board have any questions of anybody who spoke? Last chance, because I'm going to close the public hearing. Okay, I'm going to close the public hearing, and now we're going to deliberate.
Madam Chair,
What's that?
Madam Chair,
Yes?
only if this will be helpful, I have some proposed scaffolding for your discussion.
Okay. Do you want to start, or do you want us to talk first, and then you can see if we,
Well, this is your decision, so I will defer to you, but if it's helpful, I can,
You'd like to give us
I can.
yeah, okay. We'll listen to your
Yeah.
scaffolding first.
I'm not trying to take over, honestly.
No, go right
I
ahead.
do think, however, you need to be grounded in the ordinance.
Oh, totally.
in reviewing this. And you've heard a lot of facts here, and you've had a lot of references to DEP permits and rules for stormwater, for state, and those can be helpful for context, but I would like to kind of ground you in your ordinance and why a permit was granted here in the first place, and what standards I think apply to you, with you making that decision.
Okay.
I think you need to start at 240-11.2, which is the section in your ordinance that says a permit is required for certain things. And those certain things, there's a laundry list of written permits that must be obtained from the code enforcement officer. A written permit from the code enforcement officer shall be required for the following activities: A, B, C, D, E, F, G, H, I. And you can look at all of these, so don't let me narrow you too much. But what comes to my eye is I. Roads, filling, or grading. Doesn't necessarily mean there's road construction. Any filling or grading of land is a use that the code enforcement officer has to grant a permit for under 240-6.14. So you can come back and look at this and see if there are other things that you think apply, but I think that's one.
What was the citation again, Amy?
It's
240.
240-11.2.
11.2 I.
11.2. Sub I. So you ask, well, why did, not Greg, but David issue a permit? Why was that required locally? I think that we're starting down that road, right? So let's go to 240-6.14, which is the section that says road construction, comma, filling and grading. And I'm in A,
6.14.
240-6.14. These are your general performance standards outside of the shoreline zone and resource protection. It says on lots greater than 5 acres in area, blah, blah, blah. I'm assuming this is not a lot that is greater than 5 acres in area. And then it goes on to say on lots of 5 acres or less, and on any lot when the planned use is to serve no more than 2 residential units or a use accessory to an existing single-family home, such construction, grading, or filling requires a permit from the code enforcement officer. So one question for you: you interpret the ordinance, that's your charge, is to determine whether that language sufficiently fits here. And if you do, then I think you need to look at the applicant's suggestion that 240-5.11 applies to you.
What
And
is it
that-
again?
Sorry,
240.
240-5.11. And that section of the ordinance is Article 5, and I'll read the preview to that, or the very first prefatory comment, which says, in addition to the town regulations in Article 6 and the performance standards for specific activities and land uses in Article 7, the following performance standards shall apply to land uses in the shoreland and resource protection zones. Okay, so 511 falls within that. All of these standards that you find in Article 5 pertain to uses in the shoreland and resource protection zone. I do think that is a key piece in your decision-making to determine whether this falls within that. If it does, then 511 says, any new permanent, and I'm going to skip over some language, structure within a wetland shall require a site plan review and approval by the planning board. Let me break that down for a moment. The applicant suggested the structure, there are a lot of things that, is the structure of the shed, is the structure of the culvert. We don't get to this if we're not in the shoreline zone. You get to this if you're in the shoreline zone. If you get to this because it's in the shoreline zone, then is a culvert a structure? Are we dealing with a shed? These are questions I'm asking you to think about as you deliberate. Or what is the permit issued for? Is it for the shed? Is it for the culvert and the filling and grading? If it's only for that, is that a structure? You might need to look at the definition of a structure. I've looked at it. It doesn't say culvert.
Right.
I don't think it means culvert, but that's up to you. That really don't, again, that's your interpretation. So the question of whether this needs to go to the planning board by ordinance is something that you probably need to discuss.
Okay.
I think the other key word in this section is wetland, and that goes to, we've already discussed, whether this is a freshwater wetland. The definition of wetland in your ordinance says any one of these kinds of wetlands, freshwater, forested, coastal, et cetera. And so if you fit within that definition, then arguably you would be within Article 5. If you don't fit within it, then arguably none of the standards in Article 5 apply. And then you're back to 240-6.14. Many more things can happen, but I think that seems like a starting point for your discussion. Hopefully that's helpful and not confusing.
Okay. It was
Jury's
help-
out on that.
No, well. Who would like to talk first?
Well, I can jump in real quick. I would suggest that we go after Article 5 first and make a determination of whether or not it applies. So then we can either include that one or take it off the board.
Can I do something preliminarily? I think that, two things. I don't think that we formally made everything a part of the record that was submitted. I just want to do that at my front, just to make sure that everything that was submitted to us that we got previously is made a part of the record. And then,
I think if it came from code enforcement or from your office, anything that we got would be part of the record.
Yes.
So
just want to hear it. yeah.
Okay.
And then, I don't know if we want to go over the nicety of the 30-day requirement.
Paul, excuse me, Paul, could you?
I'm sorry, I think that do we need to go over the nicety of the 30-day requirement for the appeal? Because I think it was filed beyond 30 days. And it's got to be within 30, but we have the power to waive.
it was a holiday weekend. I don't have a problem with it.
No,
but
I don't either. I just want,
Okay.
I just want to make sure that there isn't an issue about it later.
Okay. So do you want us to vote? You think we should vote?
Yeah, I
To-
think just a quick vote on that.
Okay.
I'd move that we waive that we extend the 30-day requirement to accommodate the application of the applicant, Eagleson Graham.
Second.
All those in favor? Okay, unanimous.
Thanks for bearing with.
Thank you.
Not a
Paul.
problem.
Oh, back to me.
Back to you.
Yeah, so Article 5. Article 5 is the question around whether or not it's shoreland or resource. Is that what we call it?
Resource protection.
Resource protection. So I think we first need to determine, does it meet either of those criteria? If not, then 5 doesn't apply at all, right?
Correct. And do you believe it meets the criteria?
Based on the definition that we reviewed earlier on freshwater wetland, I think that it may not apply, but I guess I'd like to review that one more time and make sure that, as a board, we agree with that. So, let me
Somebody
get-
bring it up.
Galen's going to give us an answer to that? Do you want to just read it?
You want to read it? We can read it.
Okay, here you go, Kevin.
Okay.
I should read the whole of the freshwater.
Okay, so you want me to read the?
Yes.
So freshwater wetland. So A, freshwater swamps, marshes, bogs, and similar areas other than forested wetlands, which are of 10 or more contiguous acres or of less than 10 contiguous acres and adjacent to surface water body, excluding any river, stream, or brook, such that in a natural state, the combined surface area is in excess of 10 acres.
Which it's not.
So, and I think Galen was asking the question about how, what's the contiguous swamp area? And I don't know that we have anything definitive there, but it sounds like it's, based on what we know, it's less than 10 acres. Far less than 10 acres. Okay. Okay. So, in that case, that would not include it as a freshwater wetland. And then 2, inundated or saturated by surface or groundwater at a frequency and for a duration sufficient to support in which under normal circumstances do support a prevalence of wetland vegetation typically adapted for life in saturated soils.
Jim?
Yeah, so,
Did we get a response to that? 2? Galen, did we get a response to that when we went over that?
Did we get a response on the,
The second
but
item under
it's
A.
connected to a stream, is that what the,
No,
No.
this is under A2. I believe A1 and 2 are meant to be read together,
Oh, I don't, is it?
because there's an and.
And, oh, yeah.
oh,
So you have to have 10 or more contiguous acres
okay,
plus,
so it's an and, it's not.
plus
one
the
or other
characteristics
and.
of
Oh,
two.
I see the and now. Got it. So that didn't apply.
So that sounds like that it doesn't meet that definition of wetland,
Right.
so that would take it outside of Article 5?
So B and C are not ands though, right? On this, or are they?
A and B are ands. C would be its own.
Oh, C is its own.
A, B, and C are 3 different ways in which you can get a
Yeah,
freshwater
right.
wetland.
So we're on B now.
Okay.
Right.
So B is freshwater wetlands may contain small stream channels or inclusions of land that do not conform to the criteria of this definition. Small streams, channels, or inclusions of land.
you need me to read the definition for stream?
Perhaps.
I mean, it's in the,
Well, there was some debate.
it's in here.
I just want to, make sure we're thorough when we
From the discussion
go
as to whether
through.
or not it constituted a stream. Right.
A free-flowing body of water.
Yeah. It's a free-flowing body of water from an outlet of a great pond or the confluence of 2 perennial streams as depicted on the most recent edition of the United States Geological Survey 7.5-minute series topographical map to the point where the body of water becomes a river or flows to another body of water or wetland within the shoreland area. Streams with floodplains as indicated by the FEMA flood insurance maps for the town of Kennebunkport shall be defined as streams for the purposes of this chapter along any sections of their length that are located within the limits of the 100-year floodplain and outside of the shoreland zone. That's your definition.
It's a mouthful, huh?
It is.
It is.
I don't think we heard it.
But I don't think it's a,
We
And
heard
I
any
don't-
evidence to
Free-flowing.
suggest that it would
no, I don't think it's a
fit into
stream.
that category.
Okay. C, freshwater or forested wetlands of less than 10 contiguous acres, but greater than 2 contiguous acres, which are not adjacent to a surface water body, but nonetheless are found within any shoreland zone, we're not in a shoreland zone, are subject to inclusion in the resource protection district,
Which we are not in.
not in, right? Pursuant to Article 5, but shall not require any shoreland zoning structures setbacks.
Structures.
Freshwater or forested wetlands less than 2 acres are not subject to inclusion in the Resource Protection District and shall not require any shoreland zoning structure setbacks.
And we believe this is less than 2 acres. So right there, and it's not in the resource protection
But it's not,
or the shoreland
it
zoning.
is in the shoreline, right? Isn't that what it said?
Right, it's got to be less than 2 acres to be included in resource protection or shoreland zoning.
Do that again.
Well, it's not shoreland anyway.
Right, but it was less than 10, greater than 2, not adjacent to surface water body, but nonetheless are found within any shoreland zone, and we're not in the shoreland zone. So
Correct.
that's, I think that eliminates C in the long
Okay,
game.
so that would
Make us not in the shoreland zone, not in resource protection,
and
which means section 5.11
is not.
doesn't apply.
applicable. Yeah, okay,
The wetland does not drag us in.
okay. All right, so that takes care of
That takes care of that one.
5, right?
I'll pass this back down.
Sure.
Which sends us to 6, right?
So 6.14,
Right.
let's look at that. One, two.
Actually do,
I'll get to it eventually.
I actually do like paper better than the computer.
What's that?
I said I actually still like paper better than the computer.
Me too. So 6.14, road construction, filling and grading. On lots greater than 5 acres, which this is not, so we can forget that whole sentence. On lots of 5 acres or less, and on any lot when the planned use is to serve no more than 2 residential units, which this is, it's only going to serve 1, or a use accessory to an existing single-family home, such construction, grading, or filling requires a permit from the code enforcement officer. So, what they did required a permit from the code enforcement officer.
Right, so we're addressing the question of whether or not this went to the right place.
That's right.
We've eliminated the planning board under section 5.
Planning board's out,
And this is one of the areas that does steer the permit applicant to the code office.
correct.
And then the last would be
11.2,
11.2I, according to the scaffolding that we saw constructed.
scaffolding.
And I think that refers you back to 614 too, doesn't it?
At the end.
11.2I is roads, filling, and grading, road construction and filling or grading of land as described in Article
Yeah,
6.14.
right. It sends you back to 614.
Right.
Right.
So, I think the code enforcement office was the place to issue this permit.
Was the appropriate place, based on our review of these particular provisions of the ordinance.
Right. Do you all agree with that?
Yes.
Yes. Kevin?
I
Yes.
agree, yeah.
Okay. All right.
Were you in on that one, too?
Yes. So, we're at the point where,
We're not voting, we're just.
no, code,
discussing things.
where code enforcement should have issued this permit, and they did. This use permit, land use permit,
Yeah.
not building permit, even though it looks like a building permit. Okay, so land use permit.
So,
So the question is, the zoning board has a lot of authority on a very limited number of things that we can have authority on.
that is right.
So, one of the things that we have authority on is an administrative appeal, which is what this
Is,
has come before us.
is purported to be.
Right. So what we can do is decide either yes, the code enforcement officer issued this permit correctly, or no, the code enforcement officer did not issue this permit correctly. That's what our decision is.
Well, let me
Did he
make
make
it
a
more
mistake?
complicated.
Oh, of course, Paul, of course.
So under 249.2A1, which is where this authority is bestowed upon us in this ordinance,
Right,
we're to hear and decide on a de novo basis, which Amy discussed earlier what de novo is, where it is alleged by an aggrieved party that there is an error in any order, requirement, decision, or determination made by or failure to act by the code enforcement officer, and here's her review of and action on a permit application under this chapter. So, I wanted to understand just what was the error that was alleged by the appellant that the code officer made.
correct.
And in my opinion, there were issues with the filling of wetlands, and that there were dissatisfaction with how things are addressed within the ordinance with regard to wetlands, and that there were several questions posed to us that we're looking for answers that might not be our role to answer those questions, but they were, interesting questions that perhaps somebody could answer them. But I'm not so sure. I was trying to take notes on what exactly was the code enforcement officer's error. And the one thing that I did mention right down was that there was no consideration was given to the wetland. And I mean, that's a statement. That's not there's no proof with regard to that. And the burden of proof under
Right.
our section 9.2, I'll cite it just so we have it, under, it's 240, section 9.3, sub I, is that the person filing the appeal shall have the burden of proof. So it's up to the applicant to convince this board on an appeal of a permit that's been issued by the code enforcement office that an error has been made, and what that error is, and what the relief that is sought. And I don't think those very fundamental matters were necessarily met. I don't think that the burden of proof was met, and I'm still not sure. I don't see anything conclusive to me that that the code enforcement officer acted improperly. That's me.
So I think the appellant, am I saying that right? Specifically asked about Article 5, subsection 11, in a number of the correspondences. And so I think we've looked at Article 5 and we addressed, why in the land use permit application, why the code officer checked off resource protection zone, no, and shoreland zone, no. So, one of the questions that I think Susan asked a number of times was, what about 511? And I think we reviewed that and addressed why that would have been selected as not applicable.
But I agree with everything you just said, but is it alleged that the code officer made an error because the code officer didn't direct it to the planning board?
We would have to ask the appellant.
Yeah, no,
Right.
That's closed. I don't see the, I questioned at the beginning when I read it, how much of an appeal it was, because I didn't see a specific allegation of an error in any of the filings, for the most part. And then I haven't heard any kind of proof to establish that there was an error made by the code officer. I'm being circular, I guess I said that before already.
So I agree with you, Paul. I wanted the applicant to give me a reason why the code enforcement officer made a mistake, why he shouldn't have issued this permit. And I didn't really hear an answer that was valid for that question. I mean, Paul asked it, I think he asked it a couple of times, and still didn't get the answers that we were looking for. The burden of proof was on the applicant, and other than flooding pictures, which has been happening for years and years and years. I think I've seen flooding pictures in your neighborhood back from in the 40s, when there was wasn't there a blacksmith shop building there at one point? A long time ago. I've seen pictures from the Historical Society, and it was underwater. So the flooding is nothing new in your area. It's been happening for years and years. And I don't think that you proved that what Mr. Thomas Sulo is doing or did proves to us that the code enforcement officer made a mistake. I think that they did what they always do, and especially when DEP and the Army Corps both issued permits, it would be really hard, I think, for code enforcement to overrule DEP or the Army Corps of Engineers. So, I just don't think that they made a mistake. And had you proved to us in some way, shape, or form that they did, then perhaps this would be a different outcome. But I just can't get there. Kai?
Yes, I agree.
Alan?
Yes, I agree.
Did you agree with that, Kevin?
Yeah, I agree.
I thought he agreed, that's why I didn't ask. No.
So what about Amy's proposal
Yep.
earlier, that
So-
we maybe take a straw poll after we've finished discussing? I mean, what do you want to do, Madam Chair?
I would really love it if we could do this tonight and not have to get everybody back. Is it at all possible?
Well, it depends on how long you want your written decision to be.
Well, I mean, we don't ever write the decision the night of the hearing.
We can,
I've been on the board for 8 years, and I was on the board for 3 years before I was clerk, and we never write the decision immediately.
Well, we go through our vote, we went through all our votes, we did our findings of fact, and we did,
Right,
the decision just reflected everything that was done. It wasn't done,
it wasn't
it
written
wasn't
on,
written verbatim, but it followed exactly what we did at the hearing.
right. So I think we can kind of,
We do have a golden opportunity.
well, this is what I'm thinking, is that we can go through our findings of fact, we can, vote, and then,
the notice of decision would issue within 7 days.
right, and then
And you would ask
I or
us-
you or I or the secretary will write up the decision.
Or you could ask us to do that
Right,
For you.
or I would ask you to help me write the decision.
at draft.
But
And then we can sign it, but once, I mean, I think we're all in agreement. We could take a vote tonight and,
You need a motion probably to
right,
vote
but
on.
wait 1 second, because I know Paul's huffing over here, so.
Well, no, I mean, I think that we're in agreement in the outcome, and we need to write a competent decision.
Which
And,
Amy's gonna help me with.
well, I think that Amy is saying that if we vote tonight, then the language that we use at this table this evening, when we take our vote, if it's a final vote, that's our language,
It's part of the record.
yes?
No?
And that
Yes.
if we allow town's council to draft, according to our discussion and what we want, I know you don't want to come, you'd like to avoid the unnecessary calling of a meeting.
Right, to get everybody back
Yeah.
is not always easy, and that's why I would like to do it now while we're all here. And I'm missing The Bachelor, the finale of The Bachelor, so, you know, I mean,
We're missing the Sox and the Celtics.
I think that
so,
given the sort of pretty robust and detailed discussion of the board, I think if you would allow us to draft a draft notice of decision, that you could take a vote tonight. You can't change, the notice of decision, but I didn't hear a lot of controversy tonight, so
is that okay?
if that's the pleasure of the board, I
It's
think
definitely the pleasure of the board,
we can make that work.
or at least it's the pleasure of the chair.
Right.
What about the rest of the board?
That would be the pleasure.
I
of the
gathered
board.
that.
This board member, yes.
Yeah, sure.
Yeah.
Kai,
I agree.
are you good with that?
Yep.
Yep, so we were all pretty much in agreement. You heard all
Took
of
good
our
notes.
discussion.
Yep.
And why we're gonna come to the conclusion that we are coming to, so. And
Game
then
plan.
you and I will work together and get this finalized.
We can do it.
So I would move
Perfect. Go.
that based on all of our discussion and the evidence presented, and the materials submitted, and the questions of the board, and our review of the ordinance, and our determination of what sections applied and which sections which were asserted, but we found to be inapplicable, that the board finds that the appellant has not met the appellant's burden of establishing that the code enforcement officer made an error when issuing permit number 24-17 on January 19th, 2024, and that the appellant did meet the burden of establishing evidence that would suggest otherwise, and therefore we deny the appeal.
Do I hear a second?
Second.
Any further discussion? All those in favor? It's unanimous. Sorry, Susan.
We need a
That's-
motion to conclude.
Yep. Do we have any other business that we need to take care of?
I do have just an announcement for you all.
Okay.
You do have training upcoming. I think Paul and April, you're fine with your ZBA training, but there is, the rest of you need to go through MMA's ZBA training. So I'll be sending out information when I have those webinars available to you.
I haven't seen,
Yeah, they haven't listed it.
they haven't listed it lately,
Yeah.
yeah, okay.
Yep.
So when it comes up,
Yep,
Alan,
you're all due.
it'll be a webinar?
Might-
I
most
don't have
likely
to
a
go to
webinar.
Augusta?
Yeah.
Okay, so Alan and Kai and,
Am I due as well?
I
Have you
think
done it?
are. Yeah, I have a list.
I thought I had done it, but
I haven't. When is it?
ZBA
He's gonna-
training?
I know, but when?
They haven't come out with it yet.
Okay.
Oh, is that a next one?
Maybe.
Oh, maybe.
Maybe.
Okay, can we,
We need a
how about a
motion
motion
to
to adjourn?
motion to adjourn?
Second.
All those in favor?
Aye.
Dave, we're adjourned.